Prince Harry lost control when the palace moved closer to stripping away his last royal protection, and the shock was not only legal, it was personal. Inside the royal courts of justice, one decision pushed Harry further from the security he had known since childhood, the kind of protection that once came automatically with his name, his bloodline, and his place inside the royal family. That is what made the ruling so devastating. Harry was no longer fighting for a title, a balcony, or a return to royal duty. He was fighting over whether Meghan, Archie, and Lilibet could safely come back to Britain at all. But the palace stood behind the process, and the court refused to reopen the door. The strange part is how final it felt. So what protection did Prince Harry lose? And why did this decision make his royal exile feel permanent? The Court of Appeal delivered its judgment at the Royal Courts of Justice in London. The ruling dismissed Harry's attempt to overturn the security arrangements imposed whenever he visited Great Britain. 3 judges, Sir Geoffrey Voss, Lord Justice Bean, and Lord Justice Edis, considered the challenge. Their decision preserved the special system created after Harry's royal status changed. The case was recorded as 2025 EWCACIV 548. The judgment upheld the earlier conclusion that Ravek could replace Harry's automatic protection with a case-by-case arrangement designed around individual visits. Harry's response supplied the emotional force behind the confrontation. He said he was devastated and described security as the issue that mattered most to him. The defeat removed the legal route he had used for years to recover the protection once attached to his role. Harry argued that Meghan and the children remained exposed to dangers connected to his birth, military service, public identity, and position as the king's son. Leaving royal duty had not removed the attention surrounding his family. He connected the judgment directly to family separation. Britain was the country where he had grown up, served in the military, and inherited his royal identity. Yet he said the security structure made bringing his wife and children back impossible under the present arrangement. Buckingham Palace answered that the courts had examined the issues repeatedly and reached the same conclusion. The response drew a firm institutional line. Harry had lost in court, and the palace would not publicly support another attempt to restore his former guarantee. The speed of the public exchange exposed how deep the conflict had become. Harry spoke as a son who believed his family remained in danger. The palace answered as an institution defending a process already upheld by judges. Neither side left room for the other interpretation to control the result. That made May 2nd more than another legal date. It was the moment Harry's private fear, public anger, and family separation met one final refusal. The automatic security he had known since childhood had moved permanently outside his control, and every future return to Britain would begin with that loss. The process began on January 8, 2020, when Harry and Meghan announced their intention to step back as senior members of the royal family. They wanted financial independence and a new arrangement allowing them to divide their lives between Britain and North America. The announcement led to discussions at Sandringham. On January 18, 2020, Queen Elizabeth issued a statement describing the talks as constructive and supportive, while confirming that the Sussexes would no longer perform full-time official duties. Harry and Meghan completed the transition on March 31, 2020. They first moved to Canada and later settled in California. The public saw the departure as a struggle over freedom, money, press treatment, and royal control. A quieter consequence was already changing Harry's physical safety. On February 28, 2020, the security committee known as Ravek informed Harry that he would no longer receive the same automatic police protection whenever he entered Britain. His birth as a prince and his place in the succession no longer guaranteed the protective structure he had known throughout royal life. State-funded security followed official role, assessed danger, and public responsibility rather than title alone. Ravek replaced the automatic system with a bespoke security arrangement. Each journey would be examined through its purpose, timing, known threats, and information available to security officials. Harry would need to provide advance notice and wait for another decision. He remained Duke of Sussex and the King's son. Those identities continued drawing attention, but they no longer carried the automatic shield attached to a full-time representative of the Crown. The royal exit had altered the conditions under which Harry could return to the country he still called home. The transition therefore demanded a price Harry had not accepted. Freedom from official duty also meant separation from the permanent security network built around those duties. He could choose where to live and how to earn money, but he could no longer command the protective resources reserved for active representatives of the state. That trade became the center of every later argument. Harry believed the danger came from who he was, not the engagements he performed. Ravek treated his official role as part of the reason for automatic protection. The two positions could not meet, and the February letter turned their difference into a permanent rule. Harry employed private protection in the United States. His legal team argued that private guards in Britain could not reproduce the powers available to Metropolitan Police Protection officers. State officers could receive government intelligence, communicate through police systems, examine official threat assessments, and carry legal authority unavailable to a commercial security team. That difference became crucial when movements involved royal residences, public events, and threats crossing several jurisdictions. Harry offered to pay personally for police protection. The proposal was intended to remove the burden from taxpayers while restoring access to officers capable of operating through the British state. The courts treated payment and eligibility as separate matters. Specialist police protection could not be purchased like an ordinary private service. Harry's wealth, therefore, could not buy back the operational shield he had lost. The missing protection became his last working privilege as a senior-born royal. Automatic access to state-coordinated officers familiar with royal movements and national intelligence. His title remained visible, but the machinery once protecting that title had been removed. Under the Ravek procedures, protection could be assigned when officials decided a visit required it. Harry could not control the threshold, timing, or result. His safety depended on a process he had already accused of treating him unfairly. Every British journey required advance planning and a fresh security decision. Harry could arrange private guards around a building, but he could not give them government intelligence or police authority. Money had reached its limit. The shield he wanted existed only inside the state system, now refusing to guarantee it. The missing powers included access to national threat intelligence, coordination with British police communications, and the authority carried by armed officers operating under public law. These were the parts of the shield Harry considered impossible to replace. A private team could respond to danger it could see. State protection could receive warnings before that danger reached the street. Harry's demand centered on that difference. He wanted the intelligence network, movement planning, and police authority restored before his family arrived, not offered after another committee had decided whether a specific journey justified them. The refusal to sell those services also removed Harry's financial argument. He could pay the cost and still remain outside the system. The palace transition had taken something his personal fortune, American security operation, and royal title could no longer recover. Harry's fear began long before the Sussex departure. Princess Diana died in Paris on August 31, 1997, after a car crash inside the Pont de l'Alma tunnel while photographers pursued the vehicle. Harry was 12 years old. The loss connected press intrusion, movement through public streets, family isolation, and failed protection inside the mind of a child who would later spend his adult life trying to prevent the same forces from reaching his wife. Diana's funeral forced Harry to grieve under worldwide attention. He walked behind her coffin while cameras recorded every step. The institution that surrounded his family could not give him privacy even during the most painful moment of his childhood. In spare and later public remarks, Harry described his determination to protect Meghan from pressures resembling those faced by Diana. Hostile coverage, photographers, threats, and breakdowns inside the royal family appeared to him as parts of the same danger. Security therefore carried emotional weight far beyond royal privilege. Harry saw armed police and access to intelligence as a barrier against losing another member of his family. Removing the guarantee meant forcing him to depend on officials after danger had already been assessed around a particular visit. Following the 2025 judgment, Harry spoke about institutions he believed had pursued his mother and continued fueling hostility toward Meghan and the children. He viewed the court defeat as another moment when the system chose procedure over his family's safety. His anger came from a wound no judgment could separate from the case. Harry believed danger increased when protection weakened, hostile attention grew, and family support disappeared. Diana's death turned every security decision into a warning about what could happen when those forces met again. The presence of Meghan, Duchess of Sussex, intensified that fear. Harry believed hostile treatment of his wife repeated the same pattern of scrutiny, isolation, and public hostility he remembered surrounding Diana. Protecting Meghan became inseparable from protecting the mother he had been unable to save. Archie and Lilibet raised the stakes again. Harry was no longer only the 12-year-old son marked by loss. He was a father responsible for preventing another royal childhood from being shaped by fear. The removal of automatic family protection struck the exact place where his memory of Diana and his duty to his children met. Every rejection therefore felt personal before it became legal. Officials saw categories, duties, and risk assessments. Harry saw the Paris tunnel, the funeral procession, and the possibility that history could return through another generation. The committee controlling these decisions was REVEC, the Executive Committee for the Protection of Royalty and Public Figures. It coordinated security for senior royals, government figures, and other people exposed to serious public danger. The system operated through the Home Office, security specialists, police information, and input concerning royal schedules from royal household representatives. It could examine threats while considering the public role that required a protected person to appear. Harry argued that the committee departed from its normal process in February 2020. He believed a full risk assessment should have been completed before automatic protection was removed from a man whose identity and danger had not disappeared with his official duties. The courts upheld REVEC's flexible authority. Harry's position was unusual. He remained the king's son and a globally recognized prince while living overseas and refusing the responsibilities of a full-time working royal. The committee therefore created a system outside the standard categories. Harry's visits would be considered separately, instead of protected automatically through status. His birth continued producing risk, but his departure weakened the institutional basis for permanent state security. Royal household representatives could provide practical information, but the security decision rested with the committee chair inside the government structure. The palace stood close to the process without carrying formal legal responsibility for its final outcome. That arrangement trapped Harry inside a system he distrusted. His safety depended on advance notice, official assessments, and decisions made after royal and government information had been considered. He responded by taking the conflict into court, beginning a legal campaign that would consume 5 years. The distinction between status-based protection and event-based protection became the foundation of the dispute. Status had once protected Harry continuously because his work required regular exposure. The new arrangement protected selected movements only after officials examined the event. Harry argued that danger did not disappear between events. Threats followed his name, marriage, military history, and public disputes, whether he was attending a ceremony or visiting a relative. The committee's system forced him to prove that danger repeatedly. Ravek's power therefore reached into the practical details of Harry's family life. A funeral, court hearing, charitable visit, or private meeting could each produce a different security response. Advance notice requirements gave the committee time to decide while leaving Harry unable to plan with the certainty he once possessed. Harry's challenge targeted the lawfulness of the February 2020 decision. He asked the courts to examine whether Ravek had treated him fairly when it removed the protection attached to his former royal position. His legal team argued that the bespoke process placed him and his family in an inferior and unpredictable situation. The committee had changed the procedure without conducting the complete analysis Harry believed his danger required. On February 28, 2024, Mr. Justice Lane dismissed the challenge in the High Court. The judgment found that Ravek had been entitled to respond to Harry's changed circumstances as an expert body responsible for public protection. Harry filed an appeal on April 29, 2024. He maintained that the system had treated his withdrawal from duty as more important than the threats attached permanently to his identity. The Court of Appeal hearing took place on April 8 to 9, 2025. Harry attended the Royal Courts of Justice in person, turning the case into one of his most visible confrontations with the British establishment since leaving royal service. The hearing examined royal household involvement, risk procedures, and the difference between consultation and control. Palace officials could share information with the committee, but the judges placed legal responsibility for the security decision inside Ravek. By the end, Harry was fighting for more than protection on individual journeys. He wanted restoration of the principle that his continuing danger required consistent state security. The final judgment rejected that principle and left the case-by-case system standing. The hearings also exposed the distance between Harry's emotional argument and the legal test. His lawyers described a continuing risk shaped by birth and public hostility. The judges examined whether an expert committee had acted within its lawful discretion. Harry could prove fear without proving the decision legally invalid. That gap narrowed his path with every ruling. The courts were not deciding whether Harry felt safe. They were deciding whether Ravek possessed the authority to create the system. Once that authority was upheld, the protection could remain stripped, even while Harry continued describing the personal danger. The Court of Appeal acknowledged that Harry believed he had been treated badly. That grievance did not overturn the system. The judges preserved Ravek's authority to manage him differently after his change in status. The court found that Harry's unique position justified a unique arrangement. He was not an ordinary private citizen. He was also no longer a full-time representative carrying out regular duties for the Crown. Ravek could therefore assess each visit through a case-by-case security review. Harry's former guarantee would not be restored merely because his identity continued attracting danger. The ruling closed Harry's campaign for automatic protection through the courts. His final legal challenge had failed after years of arguments, hearings, and disclosures. The system created after the Sussex departure now stood beyond judicial rescue. Harry announced that he would not continue to the UK Supreme Court. He believed the litigation had shown that another appeal would not return the protection he wanted. The decisive loss was control. Security officials would determine when a visit qualified for state protection. Harry could request consideration, provide advance notice, and describe threats. He could not arrive with the certainty that police officers would surround his family from beginning to end. The judgment stripped away his last path to restoring the automatic royal shield. Once the judges closed that door, Harry turned toward King Charles III. The legal defeat became a public test of whether his father would help where the courts had refused. Harry's decision to stop before the Supreme Court appeal stage made the defeat final. There would be no higher hearing, no new judicial panel, and no further attempt to force restoration through litigation. The automatic shield had survived every argument Harry made against its removal. Judicial review standards protected the committee's discretion as long as the process remained legally open to it. Harry's belief that the arrangement was unfair could no longer reopen the door. That finality explains the force of his reaction. He had spent 5 years trying to recover one principle: consistent police security whenever his family entered Britain. On May 2nd, the law told him the old protection belonged to the life he had left behind. Harry said Charles would not speak to him because of the security dispute. The accusation transformed a government process into an intensely personal conflict between the king and his younger son. Harry argued that his father possessed influence capable of changing the atmosphere around the case. He wanted Charles to step away from the process and allow security experts to complete the full assessment Harry had demanded. The judgment identified the Ravek chair as the decision-maker. Direct intervention by the monarch would cross into a government security system expected to operate through official procedure rather than family pressure. Charles faced 3 roles at once: a father whose son feared for Meghan and the children, a monarch required to respect government decisions, and the head of the institution Harry publicly blamed for his defeat. The emotional pressure increased because Buckingham Palace had announced Charles's cancer diagnosis on February 5, 2024. Harry quickly traveled to Britain to see him, demonstrating that attachment remained despite the years of separation. After losing the appeal, Harry said, "Life is precious," and spoke about not knowing how much time his father had. The words joined fear of death, family distance, and security into one public plea. Yet the automatic protection remained gone. Harry's relationship with Britain, his father, and the palace now depended on a system Charles could not simply reverse without entering the government process. Harry's anger intensified because the man he wanted to help was also the king bound to the institution, denying his demand. Buckingham Palace's response deepened the family wound. Rather than answering Harry as a frightened son, it pointed toward the repeated court decisions. The palace's institutional statement placed legal finality above his public plea. Harry heard that response while already describing silence from his father. The security loss and the broken communication became one conflict. If Charles remained outside the process, Harry believed his family stayed exposed. If the king intervened, he risked crossing the constitutional boundary surrounding government security decisions. The dispute therefore held both men in place. Harry demanded help as a son. Charles remained constrained as sovereign. The automatic shield stayed gone while the distance between them grew. Harry said he loved and missed Britain. Under the case-by-case system, he could not bring Meghan, Archie, and Lilibet back with the certainty he demanded for their safety. Archie and Lilibet are grandchildren of the king and hold the titles Prince and Princess. They live far from the country attached to those identities, surrounded by an American life created after their parents left royal duty. Family visits draw attention connected to the monarchy, the Sussex conflict, and the children's relationship to the sovereign. For Harry, arriving with Meghan and both children creates a security situation more exposed than traveling alone for a court hearing. Harry had returned for the coronation, funerals, legal proceedings, charitable work, and Invictus-related commitments. Every journey required planning around the protection approved for that occasion. The Lost Guarantee controlled far more than transportation. It affected visits to royal residences, meetings with relatives, anniversaries, public events, and opportunities for Archie and Lilibet to know their British family and heritage. Harry's call for reconciliation carried a security condition. He would not bring his family into an arrangement he believed left them exposed. Emotional repair with Charles could not move forward while Harry saw Britain as unsafe for the people closest to him. By speaking immediately after the judgment, Harry made the consequence unmistakable. The court had not taken his title or family name. It had locked the final automatic shield beyond his reach, turning every return home into a decision made by others. The children's titles made the separation more painful. Prince Archie and Princess Lilibet carried royal identities connected directly to their grandfather. Yet the security once surrounding their father's position did not automatically extend around them in Britain. Harry could show them photographs, family history, and memories from a distance. He could not give them ordinary access to the places that formed his childhood while believing their movements lacked the required protection. The dispute placed royal heritage behind a security gate. British family visits became negotiations involving schedules, advance notice, threat levels, and official approval. Harry's children inherited the names, but not the automatic shield that once made movement inside that world possible. The protection stripped from Harry was his automatic status-based police security in Britain. It had followed him as a working prince and disappeared when the Sussex transition removed him from full-time royal duty. Ravek communicated the change on February 28, 2020. From that moment, Harry's visits became subject to a bespoke assessment rather than a permanent guarantee. The High Court judgment of 2024 upheld the committee's authority. The Court of Appeal judgment of 2025 then defeated Harry's final attempt to overturn the system and recover his former status. Harry reacted with public anger, devastation, and fear for Meghan, Archie, and Lilibet. He said the result made family visits impossible under the existing conditions and connected the dispute directly to Charles's refusal to speak with him. Buckingham Palace supported the completed judicial process. Harry received no public institutional backing for another attempt. The palace response confirmed that the former automatic protection would not be returned through royal pressure. Harry remained Duke of Sussex, the king's son, and a prince by birth. Those identities continued attracting attention and risk. The permanent police structure once attached to his royal work no longer followed him. That was the last royal protection the palace-linked system stripped away. Certainty. Harry could no longer enter Britain knowing state-coordinated officers would automatically protect his wife and children. Every visit depended on advance notice and another official judgment. The consequence reached beyond guards and vehicles. It determined whether Harry could bring his children into their grandfather's country, rebuild family relationships, and allow Archie and Lilibet to experience the royal heritage they inherited. Harry lost the court fight, the automatic shield, and control over the safety arrangements surrounding every British return. The title remained. The protection attached to serving the crown was gone. The palace move began with the RAVEC letter, survived the High Court, and became final through 2025 EWC ACIV 548. Each stage removed another route back. By the time Harry spoke to the BBC, there was no remaining legal mechanism capable of restoring his former guarantee. His reaction completed the title. Harry lost control publicly because the protection was tied to every wound he carried. Diana's death, Meghan's treatment, separation from Charles, and fear for his children. The judgment did not remove a ceremonial perk. It removed the one automatic operational shield he believed his family still needed. Britain remained his homeland, Charles remained his father, and Archie and Lilibet remained royal grandchildren. Yet the state protection once joining Harry to that world had been stripped away. Every future return would happen under terms set by the same system he had fought and failed to overturn.